Welcome to Middle Class Matters. Today, 24th June 2023. Business News in English from Dr. CMA Allegation. Part 17 of Expert Report of the Expert Committee constituted by the Honorable Supreme Court of India to look into the Adani issues. Effective Enforcement Policy. Para 21. A clear view that emerged in the committee's deliberation is that there is a need to develop a proper enforcement policy that would optimize the utilization of precious regulatory resources on the field. Para 22. Proceedings initiated by SEBI in 2021-22 have skyrocketed to 7,195 cases as compared with 562 cases in 2020-21 and 249 cases in 2019-20. The sheer increase in the proceedings initiated begs the need to analyze if the settlement option is a viable alternative. Every case initiated entails an adjudicating official committing time, energy, and resources to it, and adjudicating if the executive arm of SEBI has a case to make out that can be upheld on the quasi-judicial side. Every adverse order then has two layers of appeal as a check and balance, first to the SAT and then to the Honorable Supreme Court, each of which would also expend energy and resources on each appeal. Statistics from the SAT on the institution, disposal and pendency of appeals and miscellaneous applications are set out in the accompanying compilation. Para 23. An effective enforcement policy would mean laying down criteria on the basis of which SEBI may choose from the wide-ranging scope of measures available to it. For instance, the criteria by which SEBI must choose whether to initiate proceedings, to impose monetary penalty as opposed to proceedings to issue remedial directions or indeed launch criminal prosecution shall be clear, recent and non-arbitrary. Para 24. The cost inflicted with an issuance of direction not to deal in securities cannot be quantified easily, and further complexity would be added by the period for which such directions are issued. Therefore, it is even more vital that the criterion on which choice of regulatory weapon can be made is clearly spelled out. Para 25. There is also the element of the approach to enforcement having to be consistent with the legislation and policy stance of SEBI. SEBI must not seek to prosecute old facts with an allegation of violating the ingredients of new law that has emerged from its own amendments. If the existing regulations does not adequately address a desired regulatory objective and amendments are made, care should be taken to enforce the changed law prospectively. Judicial discipline. Para 26. Besides different adjudicating officers and different whole-time members must not take conflicting positions on the same issue. Once SEBI has ruled on an issue in a particular way, judicial discipline would require that subsequent quasi-judicial iterations must adapt the same ratio unless the ratio has been upset or restated in appeal, in which case the ratio would apply with its modification by the courts. Para 27. If a ruling by SEBI is set aside, unless the appellate order is stayed by the Honorable Supreme Court or a writ court, adjudication by SEBI must abide by the law declared by the appellate order. That the statutory right to appeal has been filed is no ground to ignore the law declared in the order appealed against. If this principle is not followed, it would be akin to a person SEBI has acted against, repeating his violation on the premise that he has appealed SEBI's order and claiming that SEBI's order is not binding on him. Robust settlement policy. Para 28. Data presented by SEBI with statistics on settlement points to the fact that the approach to settlement of proceedings is still not robust. There is an unstated perception of reluctance to settle potential proceedings arising from causes of action identified. SEBI has formulated objective criteria in regulations governing settlement of proceedings, and therefore there should be very little scope to not be objective about the terms of settlement. Para 29. To effect settlements, SEBI has proposals of settlement filed by notices vetted by an internal committee which puts up its recommendations to a high-powered advisory committee. The HPAC gives its recommendation, which is dealt with by a panel of whole-time members of SEBI. The committee sought data on settlement proceedings, and the information available at this stage does not lend itself a high quality of empirical analysis. Para 30. Some trends are however visible. Data submitted by SEBI shows that for the years 2019-20, 2020-21 and 2021-22, SEBI has not differed with the HPAC in a single case. A breakdown of the recommendation being one of accepting a settlement or rejecting a settlement is not available. Likewise, data from SEBI does not throw any light on the percentage of cases in which the internal committee recommends acceptance and rejection, and is how many of those the HPAC takes a different view. So also data on cases disposed in a year includes disposal of cases pending from previous years. While this will not indicate the percentage clearance of cases, it points to cases remaining pending across years. A time-bound disposal must be embedded in the law. Para 31. All of this needs a deeper empirical study. If SEBI desires to initiate enforcement in over 7,000 cases in a year, it must put in place a coherent policy on settlement of proceedings whereby financial inquiry commensurate with the alleged violation may be inflicted on the party, and yet precious resources need not be expended where a settlement is possible, achieving a remediation that subverts regulatory objectives. This is a universal principle for securities regulations worldwide, and there need be no exception for India. In the heightened initiation of enforcement, while the absolute number of settlements attempted has gone up in absolute terms, the percentage of settlement proposals has crashed to 4.79% from 42.52% in the previous year. Necessary timelines. Para 32. Adapting a firm timeline for initiation of investigations, completion of investigations, initiation of proceedings, disposal of settlement, and disposal of proceedings is a must. This must be embedded into the law. Needless to say, elements of such a timeline may be directory and other elements may be mandatory, as with any economic legislation, but the complete absence of timelines in this regard is a stark feature that needs correction. Para 33. It must also be remembered that the burden of making a prima facie case first lies on the prosecuting party, and there would have to be a time limit for continuing with proceedings on the premise that the absence of a finding of violation is only prima facie in nature. Indeed, initiating a prosecution, even of civil proceedings, and bringing home a charge and defending it in appeal is not a light matter, and with capacity constraints, SEBI has done an admirable job so far. However, the very same principle makes it vital to have a clear policy on which battles to pick. Para 34. There is yet another reason why an enforcement policy is necessary. The regulatory objective of SEBI may be better served by timely and sharp action in a few large and complex cases as compared with frittering energy and resources in thousands of tiny cases. Indeed, every single case has a consequence, but a regulator to achieve its objective, it has to be strategic on how best it can prosecute cases of serious significance. Para 35. The committee noted that the practices of Competition Commission of India (CCI), which has a segregation of its investigating arm from its quasi-judicial arm, the CCI passes an order containing a prima facie need to investigate and gives the Director General of Investigations (DG) a period of 60 days to investigate. Indeed, investigations may not conclude in 60 days, but the DG has to provide a status report and seek an extension of time to investigate. By this process, the investigation and its status and progress is overseen. Likewise, the legislation contains firm timelines for dealing with applications seeking approval of combinations, and these are embedded into the law. It would be important for SEBI to study such practices and adapt such a framework into subordinate legislation governing SEBI's enforcement. Such self-discipline provisions do not need an amendment by Parliament to the SEBI Act. Please like the video, subscribe to the channel, give your comments. Thanks for watching.